feel like I should say good evening because we're almost there. Laura D'Angelo was just becoming a good friend of mine, and then I found out that she had me speaking for 2 consecutive hours, beginning right after Julie Firstman and ending right before the happy hour. So I just informed her that she's my former friend. It is very nice to be here and an honor to be able to speak with Larry this afternoon, truly accomplished trial lawyer. And you'll see if you looked at your program, our topic was generally experts, and I'll get into that and explain what we're going to do in a second. I did not then take the second hour and make it about experts just to bore you with monotony for 2 hours straight about the same topic that doesn't apply to several people in the room if you're not litigators. But I hoped that it might be interesting to talk about the law of experts during the first hour and some of the litigation experiences that Larry and I have had, and then to segue into the ethics hour with a topic that we've just been introduced to, and have a little bit of a lively discussion about different issues, hopefully some fun issues, hopefully some issues that people have actual involvement with. I certainly have had the sort of ethical quandaries that come up in our ethics hour dealing with expert issues. So the plan was to make it more interesting, not less, and I hope it works out that way. The first hour really is about experts generally, with a focus on the litigation context. And it's obviously a very broad topic. There's a whole lot of law out there about experts, and probably the biggest takeaway that anybody can get about experts from any presentation is that everything about experts and about their use and admissibility and whether you're going to succeed with a particular expert depends on the law of your particular jurisdiction. So Larry and I have put in the materials some snippets of law on key issues related to expert witnesses from, I think, 4 jurisdictions. We used our own jurisdictions, Pennsylvania and Florida, respectively, Kentucky and California. We could have used a lot more, but the idea here is to really, it's sort of like law school and all litigation. It's about issue spotting and knowing what key issues are, and you can't walk out of CLA thinking you know the law and then you take that into court, because you always have to check what the law is in your particular jurisdiction anyway. So hopefully you'll get a sense of the big issues dealing with experts. Experts are crucial, I think, to anybody who's in the business of representing equestrians, certainly litigators, but even those of you who are transactional lawyers need to think about the kind of experts who advise you, and if for goodness sakes you end up in litigation, the kind of experts that are going to be able to support you and help you to defend what went on in the transactions when you're in litigation. I was out in the hall just during the last break talking to one of our colleagues, to Christian Nelson, about our respective experiences before the USCF, both representing clients in administrative hearings, disciplinary hearings before the USCF. And in the course of a very brief discussion with Krisha, we talked about expert veterinarians, toxicologists, and trainers. And those are just 3 key areas where all of us interface with experts really on a daily basis in our equine practice, whether we realize it or think about them as expert witnesses or not. They are. Beyond that, obviously we all deal with appraisers, we deal with accountants, and many others who are providing opinions, and opinions that ultimately we may need to defend our clients in court. We're to bring cases on behalf of our clients in court. I usually defend my clients in court. Sometimes we're on the other side of the gate. The first key issue that I want to address with respect to experts is the issue of qualifications. What qualifications are looked to by the courts, what the courts expect from an expert witness in order that the expert can sort of get through the door, can sit up there on the stand and be qualified as an expert witness. And fortunately, in the law pertaining to qualifications, there's a good deal of uniformity. Federal Rule of Evidence 702 sets forth the rules for qualifications of an expert witness. And most of the states now have something roughly analogous. Some have rules that are literally numbered 702 in their respective codes of evidence. Many have rules that have the same language from 702. And if they don't have that, most of the common laws of the states certainly follows 702 in the sense that they say that an expert needs to be qualified by virtue of skill, knowledge, experience, training, or education. Typically, experts must be able to help the trier of fact to understand the evidence to determine fact and issue. Testimony of an expert must be based on sufficient facts or data. Testimony must be the product of reliable principles and methods, and the expert must have applied those principles and methods to the facts of the case. Most courts are fairly liberal on the qualification prong in assessing whether an expert is actually qualified and meets the broad test that I just outlined. The showing typically isn't that high. And the showing, the idea is generally that the expert needs to have some degree of knowledge that is more than what the average juror would have and would break the case. And that the expert is bringing some additional education to elucidate a point or points to the juror. In Pennsylvania, our rule specifically says that the expert needs to have knowledge beyond that presented by a layperson. And I don't know if other state codes have exactly the same language, but that's the gist of it, is that the expert's bringing forth knowledge beyond that presented by a layperson. Now that said, we included a couple, I think 3 cases in the course materials. Frankly, we'd have included more cases, but there aren't all that many cases that are reported that deal with experts in the equine area for whatever reason. I think it probably has to do with the fact that there aren't that many disputes that are worth going over appeal or worth resulting in a reported opinion that turn on expert evidence. But 2 of the cases that we have in the materials deal with qualifications of expert witnesses, and I think elucidate to some degree what the courts are looking for, though I'm not sure they can be reconciled entirely. One of them is called Ansick versus Hillenbrand, and it comes out of federal court in Indiana, so we're applying Federal Rule 702 there. That case concerned whether a horse had a propensity to be dangerous because it was blind in one eye. So there was an injury, the plaintiff was injured, and the plaintiff attempted to rely on an expert who offered an opinion that she was injured because the horse was blind in one eye, and the opinion was to the effect that horses that are blind in one eye tend to be dangerous. The proffered expert was a, quote, horse and horseback riding expert, which, I mean, that sounds pretty general. Probably the litigators out there thinking I would have defined it a little bit more narrowly to make it sound a little more special. But that said, horse and horseback riding certainly was germane to the dispute, and most jurors are not horse and horseback riding experts. So if the expert has a decent amount of qualification, you might think that expert would be qualified. This expert's credentials, according to the reported case, includes 25 years of experience riding, 15 years experience boarding, 10 years experience training, 5 years experience competing, and the expert submitted an affidavit, and the expert's affidavit said, I'm an expert regarding care and training of American quarter horses. The court found that that expert was not qualified to render the opinion that horses that are blind in one eye have a propensity to be dangerous. The court noted that nothing in that expert's disclosure stated what specific experience she had with horses that are partially blind, or what education or credentials she might have to render, what other credentials beyond her general background that I just recited were sufficient to render such an opinion. Now, the court also noted something that I think may have turned the case, though, again, certainly the litigators are going to wonder, well, doesn't this happen a lot with experts? And that is, the court noted that the expert who was rendering this opinion, and again, the opinion was that horses that are blind in one eye have a propensity to be dangerous. This expert had not seen the specific horse at issue in the case. And in my read of the case, I think that's an important fact. I think the court noted that that was an important fact in the court. I do think you could question whether that should be an important fact, because those of us who deal with experts, I assume we all try to be careful to give our experts as much information and as much practical experience with the case. I'm sure Larry will discuss this when he talks about some more practical aspects of litigation and expert issues. But sometimes you can't get your expert to actually go see the horse or see the product or see the airplane that crashed or whatever it is. And so discount the expert's opinion because the expert didn't have that first-hand eyeballing of the matter at issue. But typically, experts are allowed to testify even with that limitation. In this case, though, that seemed to have been a very important factor in the court finding that this expert, with the general credentials I discussed, was not qualified. On the other hand, another one of the cases that we cite is a New York State court case, and this came out of the state as opposed to federal courts, called Kenny versus Lesser. And this case sort of presents a stark example on the other side. It sure seems a no-brainer. At issue in Kenny versus Lesser was whether the death of a horse during surgery was the result of veterinary malpractice. And the plaintiff proffered, the question had to do with anesthesiology, and the plaintiff proffered an expert on the standard of care. The expert that was at issue was board certified in veterinary anesthesiology, a professor at Tufts Vet School, had lectured around the country regarding anesthesia, and had personally anesthetized approximately 2,000 horses. The defendant nonetheless claimed that this expert was unqualified to render a standard of care opinion because the expert had practiced in a quote-unquote university setting as opposed to a clinical setting in the area of the country where the incident took place. But in this case, the court said that this goes to the weight of the evidence, not its admissibility, which seems eminently clear that it should have gone to the weight of the evidence and not the admissibility, because surely that expert had very, very specific and relevant experience, training, background, credentials on the whole. And the fact that the expert hadn't been in a clinical practice recently, again, that's an issue for cross-examination, but it shouldn't go to qualifications, particularly when the courts typically set a low threshold, as I've described, for qualifications of an expert. So the first issue you want to be thinking about when you look for your experts is, what are the qualifications? And you want to be careful. The cases are hard to follow in terms of finding a straight line that tells you when your expert's going to be qualified by the court, when the expert's not. My view of the world is I go for the best expert I can and get, sort of take all the credentials of the various experts that come forward and try to get the one with the most, and the credentials that are most germane to your case, and hope it sticks. But you definitely need to look, and look closely at the issue of credentials. A lot of times when we go for experts, we go for we find materials about generalists who are experts in all sorts of different areas of things, and they try and persuade you that their experience will be relevant to the matter at hand. And you need to be pretty careful to satisfy yourself that a court is going to believe that the experience is somehow germane to the matter at hand and the expert is sufficiently qualified. The next major issue, and perhaps the hottest issue now since at least 1993, so it's hardly a new issue with respect to experts, is admissibility of the expert's opinion. So your expert is qualified to come to court and say, I'm an expert, and the court says, you are indeed an expert, sir or ma'am. But now let's hear about your opinion and find out whether your opinion is an appropriate one that we will send to a jury to listen to decide whether they like that opinion, or is it what used to be called, and I don't know that people even talk about it this way anymore, is it junk science? The litigators in this room have been practicing since the 90s, and I guess those who've come on the scene since after that time know that in 1993 the Supreme Court of the United States decided Daubert versus Merrill Dow, and that was really the seminal case dealing with the appropriate role for the courts in permitting experts to issue opinions on controversial or novel scientific theories. The Supreme Court acknowledged that the courts need to, at least the federal courts, need to act as gatekeepers with respect to expert testimony and expert opinions, need to more rigidly test expert opinions before they permit them to go to a jury. And the courts following Daubert, in Daubert and after Daubert, started to look to the reliability of methodologies that experts use, rather than the standard that many of us learned from the old criminal cases, the old Fry case in law school, which was whether or not an expert's theory or an expert's methodology was generally accepted within the relevant scientific community. So the shift in federal courts, and now to some degree, but by no means entirely in the state courts, was to move from general acceptance to looking at the methodology and seeing whether the methodology met certain standards. Now, to date, many state courts still use the old Fry standard, so this is definitely one where you need to be issue spotting and you need to be up on your state law. You need to make sure that you know whether you're in a Fry jurisdiction, general acceptance, or a Daubert jurisdiction, or something in between. And there are jurisdictions that try to apply some sort of hybrid standard. Pennsylvania and Florida, for example, have expressly considered time and time again whether to shift over to the federal standard, the Daubert standard, and have declined to do so. So they remain Fry states and still look to general acceptance. California is something akin to Fry. They apply something called the Kelly-Fry test. Kentucky has a Daubert-based approach, and of course the federal courts are using Daubert. And again, there's a huge difference in which standard is used. There's a huge difference in how the standard is going to be applied, so you really need to know. And the difference will go to not just how the court assesses the expert's testimony, but in some jurisdictions, particularly jurisdictions that are using Fry, the difference will affect whether or not the court will even entertain a preliminary challenge to whether the expert's testimony, the opinion, should be admissible. Most of the time, this issue of whether or not an expert opinion is admissible will come up as a result of a pretrial motion, either a motion in limine or summary judgment motion or some other pretrial test where you're asking the court to analyze the expert's opinion, sometimes to take testimony from the expert and to assess whether or not the expert's opinion should go to the jury. In some jurisdictions, you do that right in the middle of trial. You'll have a break before the expert testifies and you make a proffer on the issue. In many Fry jurisdictions, the court will only scrutinize the methodology if it represents novel science. So recall back in 1993 when Daubert went up, it was really, the issue was a pure science issue, a question of scientific causation, and it was a question of novel science that hadn't yet been tested. And the concept that was floating around in the courts and in pop culture, there's a lot of articles from technical journal Science Magazine down to the Newsweeks and Times of the world was, are the courts becoming filled with junk science? You got all these novel theories of science, and they get into the courtroom, presumably before jurors who don't know how to parse out what's real and what's make-believe, and perhaps we should do something about this. So in the early goings, the notion was we're going to limit the junk science that's coming into courtrooms. Now the federal courts, post-Daubert, have expanded their testing methodologies to go beyond just scientific theories and just novel scientific theories. But many state courts still have rules that say we're only going to look at the ones that are truly novel science. So you need to know before you make your challenge, again, what law your jurisdiction is following and what they're going to analyze. The Daubert test in federal court does include, as one of its several factors, a look at whether or not the theory being proffered is generally accepted. That is one of many factors that the federal courts will consider, but it is not any longer the exclusive factor. Rather, the federal courts now look to whether the theory can be tested, whether the theory has been subject to peer review and publication, what the known and potential rate of error of the technique or theory is, and the existence and maintenance of standards and control. So it's a multi-pronged approach that the federal courts are using. And again, many of the federal courts are using it beyond just novel scientific theories. So that's admissibility. The next and really the last major issue that I want to introduce before Larry speaks is discovery of testifying experts. Again, I think this is something that people take for granted to some extent, and there are a lot of misimpressions of what the law is on discovery of testifying experts. Most people, certainly most litigators, know that if you have an expert who is not going to be a testifying expert, that is somebody who you bring in merely to consult, to provide you with a second opinion, whatever it is, but not to stand up or sit down on the seat in court and testify. If you have consulting expert, usually there is little to no discovery available of that person. There are some quirks in certain jurisdictions, but for the most part, you don't get discovery of the other side's consulting expert. Testifying experts are a whole different story altogether, and that's because this is somebody who's going to take the stand and be usually the centerpiece of your opponent's case at trial. And so in most courts, you're permitted a good deal of discovery about not just what the opinion of the other side's expert is, that usually comes by way of a report that's provided to you, but what the bases are, what the expert is relying on and what the expert is not relying on, and how you might be able to confound the theories of the expert. Major issues on expert discovery, and I'm going to say expert discovery, I'm talking about testifying experts, not consulting experts. Two major issues that we see in the courts now are whether communications between the hiring attorney, between me as the attorney representing a party in a lawsuit, and my expert, the expert that I hire for that lawsuit, whether those communications are discoverable. That's a very hot topic in litigation now. As many of you know, the federal rules were amended not too long ago to address that issue. And whether you can depose the other side's expert. Now, the deposition issue, there's a limited amount of jurisdictions that take the minority view on that issue, and I'll get to that at the very end. In terms of communications between experts and attorneys, again, I think many of us sort of grew up in litigation with the rule that you tried to limit the communications that you had with experts. You certainly tried to limit, as the attorney, the communications that you put down in writing when you were communicating with your experts, because we were told to assume that the court was going to decide that communications between counsel and the expert were not privileged. The expert is not your client. The expert is somebody who's supposed to be neutral vis-a-vis the parties and the court and the jury, and just there to provide good information to the jury, to educate the jury, and your communications weren't privileged. And the old Federal Rule 26, the sort of omnibus discovery rule, used to require disclosure of data and other information considered by an expert witness, and that included draft reports that experts would prepare and other communications. Now, Rule 26 has been amended, and if you didn't know it, you need to know it. That Rule 26 has been amended to require disclosure of only facts and data considered by experts in forming their conclusions. And communications with the attorney, including draft reports, are now expressly protected. So in federal court, you have a much broader degree of protection for your communications with your testifying expert witnesses, and that makes a huge difference in terms of how we practice law. Frankly, it makes things a lot more efficient between counsel and experts, and I think that was a major motivating factor for the board, for the Rules Committee in changing the rule. The states are not all of the same mind upon this issue. And it's hard to tell. Some of the states are difficult to tell. In Kentucky, there's a case called Hager versus Allstate that acknowledged the general practice that communications between an expert and counsel were privileged, but it then permitted disclosure of a draft expert report for the purpose of testing the expert's credibility, for the other side to test the credibility by comparing the draft report with the final report. And you say, well, if they're going to do that, that pretty much gives you leeway to take a full discovery of the draft report and the communications with counsel. Florida's rules do not expressly shield draft reports or communications with counsel from discovery. California permits discovery of communications with testifying experts. So again, California permits discovery of communications with testifying experts. Pennsylvania, my home state, as in so many other issues, is still in flux. We've had a lot of litigation on the issue recently. We've had a change of the rules, and literally, as I speak, the Supreme Court of Pennsylvania is considering some demolition opinion on a case called Barrett versus Holy Spirit, where in the trial court, the trial court said the communications were privileged and could not be discovered. The Superior Court, which is our middle-level appellate court on a one-person, in the initial panel, 3 judges, ruled that the communications were not privileged, and therefore that there could be discovery communications between attorney and expert. The Superior Court then reheard the case en banc and went the other way and said they are privileged, and the case was recently argued before the Pennsylvania Supreme Court. So eventually, with some luck, we'll have a clear rule in Pennsylvania soon. But again, that obviously for anybody who is doing any degree of litigation where you are working with experts, you need to know, certainly by the time you hire your expert, and really before you start communicating with your experts about being hired, you need to know the law in your particular jurisdiction about whether your communications are going to be discoverable. And the final topic that I alluded to before, and I can summarize quickly, is whether you can actually take the deposition of an opponent's testifying expert. And I think most people, again, take this for granted. The federal rules were changed many years ago to change the situation from one where you needed to show cause in order to get an expert's deposition to one where you get an expert's deposition as of right without any show cause or any cause shown. So the federal courts, you can take an expert's deposition. Kentucky, you can take an expert's deposition. Florida, you can take an expert's deposition. California, you can take an expert's deposition. And you know how I'll conclude. In Pennsylvania, you cannot take an expert's deposition. People are shocked to hear this. Out-of-staters come to our courts all the time and ask me when we're going to take the expert's deposition. They talk about how we're going to nail that expert in the deposition. I say, what are you talking about? You need to show cause in Pennsylvania in order to take an expert's deposition, and I truly cannot think of a case in my 23 years or so of practicing all in litigation at a pretty sizable firm and doing a heck of a lot of Pennsylvania litigation where we were able, or where some party in our case was able to show cause to get the deposition of an expert witness. So if you come to Pennsylvania with your cases, you better just assume you're going to win it at trial. And with that, I will give you Larry, who will talk some more about some of the practical aspects.
Thank you, Ben. Sometimes I start in court by saying, may it please this honorable court. My opening remarks, I don't have a joke either, but I think we ought to take just a minute and consider how fortunate we are to be able to hear in the next couple of days from the people that we're going to hear from. I mean, we're going to hear Ned Bonnie talk about race day medication. There's probably not another person on the planet that knows more about that than Ned. I know I'm leaving a lot of people out. Frank Becker reads more Equine law cases in a month than I'll read in 2 years, and gives us the benefit of that every year. It's really, I've been doing this now for a long, long time, and it's really an amazing opportunity to try to become current and get the current state of equine laws. It's really grown to be quite an amazing event. That having been said, I'm going to try to be really practical in terms of offering some suggestions on how to do certain things pertaining to experts. And these are just suggestions, and I know a lot of you out there have far more experience at this than I have. What we've included in the materials, in addition to sort of the law review stuff, which is a little bit above my head, we put in a couple recent briefs that my firm did. We've had some actual Daubert hearings. It's just an example of some of the current law that we use in trying to exclude some expert witnesses. We also put in a couple real live excerpts from some real live deposition testimony. And if we have time, I'd really like to have sort of an interactive session about those opinions and whether you think they're good, bad, hard to deal with the trial, so forth and so on. Okay, show of hands. How many people have actually deposed your adverse witness? Most of you, that's what I thought. And crossed your adverse witness at trial. And had an evidentiary Daubert hearing. See, I told you, most of you guys have been doing this a lot longer than I have. Let me, even with that show of hands, let me offer some practical suggestions. I do this humbly. In terms of an expert deposition, in deposing the adverse expert, I try to accomplish 3 things. I try to write 3 bullet points on my legal pad when I go to that expert deposition. Number 1, tie down the opinion opinion that the expert is going to testify to a trial. I can't tell you how fuzzy and squishy that can be unless you tie the expert down. What is the opinion that you expect to give at trial? You haven't investigated any other areas. You don't expect to give any other opinions. You need to tie down that opinion so that you can go to work in refuting that opinion at trial. Remember also, you don't do your trial cross-examination at the expert's deposition. There's no Perry Mason moments there. What you're doing is building the foundation so that you can take this guy or girl apart at trial. Don't take your best shot at the deposition. Save that for trial. Thing number two you want to do is you want to taint the engagement process. How did this expert become an expert for this lawyer, your adversary? There's gold in them hills, I'm telling you. You need to know when the expert was retained, 2 weeks ago, and you need to know what task the lawyer gave the expert to do. It's amazing how many times that testimony will come out to be something like, well, I was asked if I could give an opinion that the horse was lame, or that this particular accounting treatment violated some accounting rule. That's sort of not the right answer. The right answer is, I was asked to investigate this issue. So you want to tie down when and what were the terms, so to speak, of the engagement. When was the opinion that you're intending to testify to reached? Also amazing, what I call the instant opinion. If asked by a lawyer, can you give this opinion? On the first phone call, the expert may say yes. Well, that leads to a lot of fun questioning about what you did to arrive at that opinion, and so forth and so on. So tie down the opinion, don't allow any loose ends, and try to, what I call, taint the engagement process, including, is this expert the go-to expert for this lawyer? We all get a list of cases and so forth and so on. And every time my adversary has to use an expert, he uses the same expert. That's some pretty fertile ground for cross-examination at trial. The third thing I try to do is try to establish exactly what the expert did from the time he was given the job, whatever it was, until the time he or she formed that opinion. And again, it's disappointing and amazing how often you get fuzzy answers about, well, based upon my general experience, I sort of had this kind of case 5 years ago, I updated my opinion and so forth and so on. What you're really looking for is what tests you did. Did you look at the x-rays? Did you look at the ultrasound reports? Did you, the classic, what treatises did you consult? All those kind of things that we think experts should do between the time they're asked to give an opinion and the time they formulate the opinion. So generally speaking, those are the three things that I try to do in the deposition of an adverse expert. Daubert hearing. We've had a couple of those, actually several of them over the last 2 or 3 years, because we've been lucky enough or unlucky enough to be involved in some big cases with a lot of expert work. Your goals at the Daubert hearing, I submit to you, are very similar to your goals at the deposition, with one addition. And that is, you want to try to convince the trial judge, again, without taking your best shot and doing your trial cross, that maybe this expert sort of doesn't know it all after all. Because what I found, I'm not sure if Sam or the other trial lawyers have found this, I found that trial lawyers or trial judges, for whatever reason, get enamored by experts. Maybe it's because they're going to hear testimony beyond the normal routine kind of stuff that they hear, and they tend to put experts on sort of a pedestal and frankly present them to the jury in a way that gives them more credibility than the normal witness. There's a lot of deferential treatment, I found, at least by the trial court, to the expert. So use the Daubert hearing, again, without taking your best shot, to lay the foundation for what you want to do with this expert trial, and pay attention, obviously, like you do whenever you're hearing, to the body language of the court, and try to figure out how the court is taking all this in, and what may or may not be fertile areas to explore in your cross. Practically, remember this, the question on a Daubert hearing is admissibility, not credibility. It's a very, very tough standard, I found, to exclude an expert witness as well as a Daubert or Fry hearing or any other pre-trial matters. So that, in general, those are sort of my bullet points for what I try to do with the expert testimony at a Daubert hearing. A couple real quick thoughts about the topics that appear on the first page of the materials, which is, I think, now page 3. I just want to focus on a couple areas. I think one of the questions raised there is, when do you need an expert? I think the first answer to that is, you need an expert when the other side has an expert. And I found it very risky to go into the case when the judge or jury is going to hear from an expert, from your adversary, when you don't have an expert to counter that, for the reasons, again, that I think the court tends to put experts on pedestals to some extent. You need an expert, frankly, when you need to, with all due respect, dummy down some scientific issue for the judge or the jury. You need, if you have some, what could be a necessary opinion, a scientific sort of boogie-woogie, you need to simplify that and explain it to the judge and the jury in terms that everybody can understand, which I found to be the biggest challenge with dealing with experts, is to communicate in terms that normal people like judges and jurors can understand, because experts, and part of the excerpts I put in the materials tend to show this, experts tend to speak in sort of jargon and language that makes the topic far more complicated than it needs to be. Where do you find an expert? I think the first place you look is, quote, in the field. If you've got a case about a racehorse, I'll look around the racetrack, or a vet, or a real live trainer, an exercise rider, believe it or not, somebody that knows the business and has lived it and can communicate that to a jury. Look in the field. Where did it happen? The racetrack, the show ring, at a factory. That's always my first choice. Number 2 is, if there's a sort of professional expert that really knows his or her stuff, that does a lot of this work in this field. Like Dave Johnson, for instance, is one of our colleagues at this, and there are no kickbacks here, at least not yet. But that would be sort of my second choice. Number 3 is in your client's office. And this is risky. You can have an expert from your company, or you represent one of the big farms. You can have an expert from within your client's organization. That saves you from doing expert reports and so forth. You have substantial bias issues to overcome, obviously. But again, short war story, I spent the last 3 or 4 years doing a lot of work for Rolls-Royce, involving the propulsion systems for cruise ships. And I was sort of faced with the quandary, do I get an internal expert from within the worldwide masses of Rolls-Royce, or do I go out and get an outside expert, thereby sort of admitting that there's somebody else out there that knows more than we do? And so I opted with using an internal expert, made sure that it was somebody that was, jury-friendly and could communicate concepts, and had his grandfather look, been doing this for 50 years, and looked like he couldn't lie with bamboo under his fingernails. But again, you have to you have to be aware of and be prepared to overcome the substantial bias of having an internal expert. I hope I'm not stepping on anybody's toes, but sort of the last place I look for an expert is the college campus. It's always a problem to me to parachute an expert in from, with all due respect, Atlanta or New York or Chicago, California, wherever. Maybe that's because I'm, Southern born in Florida and there's home cooking and so forth. But the academic expert is, to me, not the first place I look. Now, of course, every case is fact specific, and depending on what the issue is and so forth and so on, you certainly need to consider that. The other legal point I'd like to make, and I'll spend just a couple minutes with the example if we have time, is in one of the cases, and I of course forget which one it is, I think it was one of the Kentucky cases where the court admitted expert testimony. I think this was the one about the fucking dirt on the horse, by reference to Federal Rule 401. And every once in a while, we all ought to take a look at Federal Rule 401. Because, and frankly, I don't think 401 has anything to do with the admissibility of expert testimony. I think it is exclusive. Because if you read 401, which I do every once in a while because I find it scary, it's a test for relevant evidence. And it says evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence. And I submit to you that there are very few things in this world that I couldn't make a colorable argument didn't fit within that definition of relevant evidence. Any fact that has any tendency, or any evidence that has any tendency to make a fact more or less probable than it would be without that evidence. I don't know. It's Wednesday. We're at Keeneland. Is that relevant to who's going to win the Kentucky Derby? Maybe. Maybe because every time we met on a Wednesday at Keeneland, the 7 horses won in a Derby. It's just such a low threshold. It's very frustrating. And I find the use of that standard in talking about experts a little troublesome. Just a couple words about the excerpt from the deposition that I've included in the materials. And I think it starts on page E47. And I've got to give just a little context to this without telling a war story. We represented Rolls-Royce and they built a propulsion system for cruise ships. And pointer number 1, explain what we're talking about. Well, those propulsion systems are like huge outboard motors that you bolt on the back of the cruise ship and they rotate 360 degrees, and that's what steers the ship. Well, how big are they, Larry? Well, they happen to be as big as a double-decker London bus, almost exactly. And of course, we use London because Rolls-Royce is in London. And they happen to weigh as much as a fully loaded 747. So that gives you some idea of what we're talking about. We're talking about bearings in this case that are like, if anybody has ball bearings in roller skates anymore, it's a ball bearing. How big was the bearing? As big as a tractor tire. And the issue was, why did the metal in that bearing fail? We're the manufacturer. We wanted it to be something other than a manufacturing defect or the material was defective. So we deposed the expert. The expert came up with this opinion. Why did the metal fail? And this is a virtual quote. Because it was exposed to high stress levels. Whoa, what does that mean? And then he went on to say he didn't know what levels of stress it was exposed to. Well, I got out my handy dandy little visual aid plastic ruler, and I submit to you that if you submit this plastic ruler to high stress levels over and over and over, that eventually it's going to fail. And the question is, well, what stress levels was it meant to withstand? And the expert, God bless him, couldn't tell me. He didn't tell me whether it was higher than the manufacturing specs, higher than what was anticipated, and so forth and so on. So when I got that opinion, I was very happy, and I quit, and I explored that in some detail at trial. My point is, tie down the opinion, and once you have it tied down, the deposition is not the place to beat them up with it. It's save it for trial. And another, I can't help but visual aids on what trial lawyers do. The expert said, well, as a result of this higher than anticipated stress levels on this metal, it had a failure which turned out to be a scratch. I said, well, how big was the scratch? And he said, well, I don't know, he gave me some answer, of course, millimeters or something, which I later converted by going to Google inches, and I came up with this visual aid at trial. If you took the piece of metal that you're talking about and unrolled it, it would be about the size of this table. And how big would the defect be? It would be smaller than this little yellow stick. And so you walk over to the bar in front of the jury and you say, well, it's as big as this, that's a piece of metal, that's scratched on that. At least I tried to communicate in understandable terms what all this nonsense and jargon this expert was giving me at his deposition meant. And I just love the language that he gave me about being subjected to high cyclical stress and all the jargon that I quoted in the excerpt that really seemed to me, and hopefully we communicated to the jury, seemed to try to obscure rather than educate what his actual, educate the jury in terms of what his actual opinion was. I got the 10-minute sign about 5 minutes ago, and as sometimes I also say to the court, I know you gave me 30 minutes for this hearing, but I don't feel contractually obligated to use up all that time, so we've got 3 or 4 minutes. I would love to try to respond to any questions that you have between a combination of Sam doing a great job on the legal materials. I try to give you a few practical pointers. Again, I do that humbly, knowing that you could give me as many pointers as I could give you. But if you have any questions at all, I'd be more than happy, Sam and I would be more than happy to try to respond to them either here or as if we meet later on this afternoon. Anybody got any questions?
Sorry, I want to just clarify one point that sort of the juxtaposition between my presentation and Larry's. I told you that the new federal rule provides for protection of communications between attorney and expert, and Larry described some of the key topics. Some of the key topics that he examines in an expert's deposition, and some did concern communications between attorney and expert. You should know that the rule that expressly provides for protection of those communications also carves out certain areas, and they are within what Larry was describing. You can still examine, you're expressly permitted to examine compensation for the expert's study or testimony, facts or data that a party's attorney provided and the expert considered informing the opinion expressed, and assumptions that the party's attorney provided and that the expert relied on informing the opinions to be expressed. So when Larry says, I want to know what the assignment was that was given by the attorney to the expert, some of you may say, well, Silver just said we can't ask that anymore. It seems to me you still can ask that, because those are the assumptions provided and often will include the facts provided by the attorney to the expert.
You know, and with that segue, Sam, I know there's a new federal rule about, that purports to protect draft reports and so forth and so on. I'm old school. Frankly, I don't quite yet trust that, especially since in many of the state courts you can get draft reports. The most fertile area for cross-examining your expert are draft reports. It's so much fun. The expert sends the lawyer a draft, and the lawyer marks it up, and it is really fun to go over them one by one. Whose idea was this? Blah 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 blah. And I'm not, especially with many of the state courts either permitting discovery of drafts or being uncertain. I always operate under the assumption, the old assumption that's probably not accurate now, that everything I send to the expert and everything the expert sends to me is discoverable. It's like if you're on the other side of my office, we do a lot of criminal work, we always tell clients, make the assumption you're being recorded. But that's a different side of the office. But I think it's safe to make the assumption that what goes back and forth between you and your expert will see the light of day in discovery. And it's not that hard to avoid. I mean, instead of sending graphs back and forth, I mean, get together, talk on the phone, just don't have honest to God, I'm not going to try to avoid more stress. I actually had it happen one time at trial. And remember this, even if you can't get draft reports, you can still get any document that was used by the expert or any witness to refresh his recollection to testify. And I actually had it once. I took a shot. What you use to refresh your recollection to testify, and the expert said, well, a bunch of stuff, including the expert reports. And we had a lot of fun over the next half an hour debating with the judge whether it's entitled to see that or not. And of course, I wouldn't tell you the story unless it came out in my favor. And the judge said, yes, I would get it. And sure enough, if the opinion that he expressed was a light was red, in the draft, it was a light was green. It was just one of those moments. So it's a fertile area. Anything else? Again, I really appreciate the opportunity to speak here today, and I really appreciate more than that the opportunity to hear from the others in the group. It's really an honor to be here, and I appreciate your time. Thank you.